Welcome to the Slingshot, everyone. Today's guest is Cristina Caffarra. She is co-founder and vice chair of Competition Research Policy Network at the Center for Economic Policy Research in London. Cristina has consulted on competition issues for over 25 years and has done work for Apple and Amazon and Microsoft on mergers and unilateral conduct. She was the lead economist in Europe on the Microsoft Activision deal before the CMA and the EC. Now, Cristina holds a PhD in economics from the University of Oxford. She was called the High Priestess of Competition by Politico in 2023. And Cristina hosts the coolest antitrust conferences in Europe of all time. I admire them from afar. And one day, if I ever accomplish anything in antitrust or maybe win a big case, she might even invite me to come speak there. Joining me with Cristina is Darren Bush, professor of antitrust at the University of Houston Law. And Darren, while you haven't been recognized by Politico yet, or maybe you have, you will always be my high priest, especially after you wrote that amazing piece in the Sling, analogizing the consumer welfare standard to a religion. Welcome, Darren. How's everything? And welcome, Cristina. Didn't even get to say hi. Welcome, both of you.
Thank you. Thank you for having me. Hi, Hal and Darren. Yeah. It's a pleasure to be here.
Yeah, and to get you both on the phone at the same time, I know that we're great distances apart. We had to wake up Darren early in the morning for his time, and Christina's staying out late after going to the clubs and stuff. So I appreciate you guys both being here. We're gonna try to hit 4 topics today if we can. I do want to go into the DOJ's monopoly case against Google, the search case, because it's all the buzz in the news. I don't want to go back to Europe and talk about how Europe pivoted from regulation after it tried its hand at antitrust. See what Cristina thinks about that, if it's going to work. I want to get into ecosystem theories of harm. It's kind of the new rage, and how we might better stop future mergers or police future mergers. And then finally, if we have time, I want to talk about what the Europeans take of this current fog of war in the U.S. Around the soul of antitrust, and whether, if it's not going to be consumer welfare, what's it going to be? So let's just dive right in. We'll start with the DOJ search case. Before we get to that, Cristina, let's discuss what happened with Google in Europe with Google on search. A lot of our followers aren't gonna know that as well, and how Europe now has maybe passed the baton to the U.S. to try to tame this wild beast. Can you help us get up to speed?
Very briefly, and thank you for that question. The Google wars, in some way, have started in Europe. Europe started early in the path towards enforcement. As you know, there was a shopping case that was pursued starting in 2010, and then following that, in 2014, the Android case. These are the precursors to the current DOJ and states case. In fact, the Android case, which plays so much of a role in the current case, actually started in Russia. I was the economist for Yandex, one of the complainants in Russia, where the Russian anti-monopoly service effectively pursued a theory of harm. We constructed a theory of harm that was a Microsoft-style theory of leveraging from the Google Play Store to protect the dominance in search. That was started in Russia. And then we exported it to the European Commission that pursued the cases. Everybody knows the case ended in 2018 with a big fine and some cease and desist, which is the way in which Europeans phrase infringement cases, and a feeble attempt to set up some sort of choice screen as a remedy, so that when you got your phone out of the box, your Android phone out of the box, you'd have a selection of possibilities. For reasons that we can go into, that choice screen remedy never worked. And that's where the story starts really pivoting to the US. At that point, 2018, we Europeans could be quite smug and sort of look at the US and say, well, you're doing nothing. We may not be doing something very effective, but you are doing perfectly nothing. Nothing has happened in the United States since the Microsoft case. There's been a permafrost over enforcement. And there was a sense that we, however imperfectly, were pursuing, in some sense, the right battles, and we had the right motives. The transatlantic started to turn, I think, in 2019, and not necessarily just through efforts by Democrats. There was an approach that I had curious how things happen, in 2019, by one of the unsung heroes of this fight, Doug Peterson, who was at the time the Attorney General from Nebraska, who wanted to motivate and really push forward a bipartisan coalition of states to pursue Google. So the states have been absolutely a key force in all of this. They are still, of course, present alongside the DOJ, but they've started it. The DOJ at the time caught up. But in 2019, when they stood on the steps of the Supreme Court, there was Paxton and a number of Republican generals. I went to visit them in New York to try and tell them they would have the back of the world if they were to pursue this kind of case. And of course, a lot of Democratic states joined in. And then the DOJ joined up. But to get to where we are today, of course, we had years of work and discovery and preparation of the case. So we are there. We are there. And in Europe, we are watching in some way what is happening over there with deep interest, because for in ways that we'll discuss, I'm sure, in part two, we have had great ideas and initiatives in the states, and the cases we pursued were good cases, except they went nowhere. And we weren't able to move the dial. So essentially, the notion that Google is now facing US law, the force of US law is very significant. And we feel that somehow we started that journey. I remember in the early days, I was introducing the generals and the state attorney generals to European regulators in order to join the dots, because so much had been done in Europe by the UK, by the European Commission, by France, by Germany, to pursue this. We just weren't able to clinch it, to bring it to a case that could really change the landscape. Now, you say everybody's watching this case, kind of, but the big worry I have about this case is that not enough people are watching it. Us competition nerds are watching it, but the case is being successfully shrouded in reasonable secrecy in DC. And that
you showed up. You showed up at the case in the first week. I saw pictures of you.
I did show up because it was essentially the only way to really directly see what was going on. Yeah. I have great time for the Colorado team, John Sallet, and the Nebraska support, Joe Conrad, who worked on the case alongside the DOJ. But the reality is that unless you physically go into court, you do not have any other means of following directly what is going on. There is a band of dedicated reporters, Vinoli and Island, and all of these great writers. Open Markets has got people, Economic Liberties has got the journalist inside. But unless you follow the tweets, Jason Kent and so on, you are shrouded in some sort of secrecy. The exhibits are not accessible. There's been a motion filed by the New York Times, supported by a number of journalists, to get more access to the exhibits. That is still kind of tricky. So this trial is not reported as broadly. Should be front page news, like the Microsoft trial was 20 years ago, and it isn't.
So what are we missing if we're not sitting in there in the courtroom? What are we missing that you've seen that no one else is reporting about?
Well, I mean, there is of course reporting of substance, and the highlight of the trial, of course, are reported quite widely within this sort of slightly narrow bubble. The things that have been important, I think, have been the discussion around the role of defaults, because this is what it's all about. There's been a discussion about how important defaults are. And of course, here there is the tension, because Google keeps saying, we are chosen by people because we are the best, while at the same time paying fantastic amounts to get the full position on devices. And so this is going to be ultimately the nub of the case. We've had a number of vignettes. We had Alvarian, the chief economist of Google, being effectively called by DOJ at the very beginning. Not a particularly stellar performance. He was quite it was quite an unhelpful witness, but also didn't do much for their case because he was in the business of denying that data mattered. And he was then presented with exhibits that suggested that everyone else at Google thought that data mattered, and he was just trying to somehow diminish the importance of that. There were a number of other interesting sort of flashy moments, like the appearance of Satya Nadella, who's the CEO of Microsoft, and he did quite a good turn. But I think in substance, the key is going to be really how one interprets the payments that Google makes to OEMs and to other players for that default position.
So
now, there's been.
Can I just try a frame on you? Because I do want to talk about the payments, and a lot of that, and just as you said, is being motivated as payments for default positioning. And what I'm concerned about is that defendants can come up with efficiency stories for payments for exclusivity. They love to talk about supermarkets as payments for shelf slotting all the time. But when I read that news, and I just want to give you something that came out in the New York Times last week, that actually Google got the sense that Apple was going to start competing with it in search. And the story came out about Apple's, it's called a search tool on iPhone called Spotlight. It began showing users richer web results like those that could have been found on Google. And then we have a Google document from 2014 saying, quote, "We expect these suggestions to siphon queries away from Google in verticals where Spotlight is triggered," end quote. And what I wanted to ask you is, should we be thinking about this as a payment not to compete, which really lacks any kind of pro-competitive justification, rather than a payment for exclusivity?
Well, that's the effect that it practically has, and it is also the motivation. Look, I was struck by the great big amount of hoo-ha at the volume of money involved. Right? I mean, everybody kind of fainted when this sort of figure of 26 billion came out. I don't know if I'm in a particular spot, but in Europe, that kind of figure was known. We knew it was floating around. We're not talking about 200 million. We knew we are talking about tens of millions. And the fact that that figure has increased also exponentially is not surprising. It's a revenue share. If the revenues grow, if the ad revenues grow, then the share will grow. So it's power law. So I find the surprise around the actual figure surprising. What is the fundamental question is, it's a large amount of money. As you say, Google has been trying to, and we've yet to see the full defense play out. But the indication is that their arguments go around, well, there's nothing unusual about this because it's like a supplier paying a supermarket for position, except when you're the sort of the monopoly supplier of the product paying effectively the only supermarket for position, then that takes the essence of naked exclusion. So no one can effectively match what you're paying. Nobody could. And yes, there is, of course, also the sentiment that to the extent that Apple could have started an alternative service, you want to pay them to kill it. So I think that, to me, is the obvious interpretation of what goes on, and this will really be what the case turns on.
Yeah.
Google is coming up, or will come up, with efficiency defenses. I think the obvious inference that one can make from a payment of that size is it cannot be described as payment for space. Paying for default, I mean, you don't find it a helpful framing. I think it's what it is, literally, but it is, of course, a way to keep out others because no one can match you. That was the history of the choice screen in Europe. Yes, there is a choice screen. Everybody has to pay to be on that choice screen, and Google can pay the most. So the point is that is obviously a payment which is intended to preserve the moat as it is. So
let me do one more Google before we pivot, if that's okay, because I know that privacy is really important to you, Cristina, and there's a privacy angle to the Google kind of theory of harm. And the notion here is that harm, at least from the consumer's vantage, didn't take the form of higher prices. Of course, we largely get to play on that service for free. But instead, it took the form of a degradation in privacy. That is, in a more competitive state of the world, Google may have had to be more careful with our data, right? And I'm wondering, to you as an economist, do you think that theory has legs? Is that something that you think can get buy-in from a conservative judge, even if it's appointed by a Democrat, who may not have seen something like that before and is wedded to this notion that, you know, if we can't show price or output effects, we're toast? How do you think it's going to fare?
That theory is the obvious converse of a price increase. We, as economists, know that you talk about a price increase or a degradation of quality as effectively equivalent in sort of demonstrations of market power. So it's not just Google. I mean, we've made, certainly in Europe, we are very aware that that is really the way in which you think about Facebook as well. The way in which market power has manifested itself has been in the degradation of quality. So I don't think that's controversial as such. As you say, what will a judge make of it? It seems to me this judge is reasonably sort of sensible and open to these suggestions. And I don't think there can be very much dispute that lowering quality, by which I mean the way in which data is harvested and used in ways that in Europe, certainly we regard as problematic. Because if any, to start with, they don't comply with our data protection law. That is a clear indicator of market power. I mean, we've seen the FTC use this in the FTC complaint against Facebook. And I think it is pretty now an accepted way in which you think about market power manifesting itself. I hope the judge will understand that. I don't think that the case will turn on this, though. The case will turn on the size of the payments and what to make of them. Which interpretation he will accept.
Okay. Well, good. Let's do our pivot then to, we talked a lot about antitrust. I want to pivot to regulation because that seems to be the direction that Europe is headed in. And I know you're a bit critical of it. You've got a nice piece in Project Syndicate that I wanted to ask you about. But before we get there, kind of give the readers, our followers, just a quick background on what happened in Europe. Was it a failure? Did they achieve nothing? And what do you think about this pivot to regulation? Is it the right move?
Well, the pivot to regulation has been essentially a manifestation of the failure of antitrust. We started a number of well-meaning cases. This is no reflection on the intention or the quality of the work done by the agencies. We have started cases against Amazon. We started cases against Apple. They went nowhere. They are still kind of pending or have been settled in various kind of nondescript ways. We've done the Google cases. Facebook is still there. We were late with AdTech, yes. But in general, the sentiment here is that we started enforcing against digital giants for over a decade, and there's been no change on the ground. And so they have member states, because remember, it's not just the Commission, it's France, it's the UK, there's Germany. Germany is showing some success because they've taken an unusual tack. They have changed their antitrust law to make it a more hybrid form of antitrust and regulation. And to your point before, they've actually taken the position that violations of data protection law are ipso facto violations of antitrust law. That's really novel. Germany has been a pioneer in this place, essentially saying to Facebook in particular, the way in which you are violating GDPR, our data protection law, is a form of violating the antitrust rules and a form of abuse of dominance. Germany has taken a very novel and interesting tack. But in general, the sentiment is that antitrust has failed. And why has it failed? I think for a combination of reasons. It's taken too long. These processes are grotesquely elongated. The rights of defense are very, very long. There is, of course, several layers of appeal. We're still in the appeals of the search, the shopping case, which ended in 2014, with no real final decision. There is a question of posture of regulators. I think posture matters enormously for regulators. If regulators are combative and aggressive, that makes a big difference. And there is a sense that, frankly, in Europe, because we are Europeans, we cannot be ultimately too interventionist in structural relief. I mean, imagine the total uproar if a European regulator decided to somehow impose a structural breakup on an American company. There would be uproar. Now, the European Commission is talking about taking structural measures in the Acte case, which is strongly along, but they won't do that before a US court does that, because it would be impossible. So given that we basically are sitting there and we've done good cases, but we got nowhere, then regulation has become a natural pivot. And to the credit, I think, of Europeans and the democratic process, you've had dysfunctional kind of spectacles kind of in Congress, in the Senate, over a number of bills that were put forward, never were put to the floor of the House. This is a US story that we were watching with interest. In Europe, to the credit, I think, of the system, we were able to pass a digital regulation within months. By the end of 2020, we had it on the books, and it was a great democratic initiative, which was multi-party. So in that sense, it is a great development. The shortcoming, to my mind, is at least twofold. And I want to be clear. I think it's great that we have it, and I'd rather have it than not. My question is, what does success look like, and what is it going to achieve, even in its own terms? And the reason why I think this is limited is that essentially in preparing this law, what happened is the drafters of the law took all of these antitrust failed cases, did a synopsis, and essentially posited those as rules. Thou shalt not self-preference. Thou shalt not do this and that. Putting those terms without more specifics, without more attention to the business model, this goes only so far, because each and every one of the targets, the gatekeepers, as we call them, can put forward a justification, a story. And in many cases, the issue is not quite that. I mean, so I think what it will achieve is a little bit more fairness in the relationship, for example, between developers and Apple. Yes, a little bit more fairness in the relationship between Amazon and Stouts, which is all great. But it depends on what your objective is. I think that these companies, will pursue this until the day kingdom comes, in terms of the potential for appealing, delaying. There's a lot of places at which companies can effectively say, stop, I'm appealing this in the court, I'm appealing this in the court. And so there will be, it's a charter for making money for advisors, because dozens of law firms are involved and they're all minting it.
So
it will take a long time. Sorry. And yes, sorry, Darren.
Yeah, I was, in terms of thinking about this regulation, and also the preferences in antitrust for structural relief, or at least we say that. When we think about the DMA, and we think about self-preferencing, which is, shown to discourage entry of independent merchants, for example, with Amazon, and you note that you have over a decade of failed self-preferencing cases in Europe.
Yeah, we do.
Is regulation the answer to that, or
no? That's the point.
Should we just let self-preferencing happen? What's your take on that?
Well, I mean, self-preferencing, again, my concern is that talking about self-preferencing in general is not particularly helpful, because self-preferencing means something in a business model which is outfunded. Then you have business models that are transaction-based, so you get a commission on the transaction. We can debate a long time what I actually think is happening in some of this modeling and whether it is really the kind of self-preferencing that people have been worrying about. I think that in many of these cases, the issue is not self-preferencing. The issue is rent extraction. And even people who've been very vocal critics of Amazon, like Darren, like Tracy, have been saying, actually, exit of sellers has not been really the main concern. In Amazon's case, the issue is rent extraction, as the FTC's complaint actually now alleges. So I think the issue with many of these gatekeepers has to do with ultimately rent extraction. This is what monopolies do. This regulation is not going to do very much. I'm not saying it's going to do nothing. I think it is going to take a very long time and be marginal in its impact. It's not going to be a wholesale reorganization of markets, because it depends on what your goal is. If you're concerned about, again, a little bit of fairness at the margin for competitors on the platform, okay, fine, I'm with it. I think about dispersion of economic power as being a much more significant goal. And we are in a world in which gatekeepers can turn to governments and say, either you do it my way or the highway. And I've seen it with my own eyes, and it happens. Because when you are, for example, the UK, having severed itself from the continent post-Brexit, you're very vulnerable to that kind of power, to gatekeepers essentially telling governments, you want the toys, then play. So I think that is the main issue, which is in a world in which the market cap of some of these companies is bigger than the GDP of some of the European countries, you really have to think about. And I think this is maybe not something that is, I think we are, yeah, great, fabulous, pats on the back. I get very amused by the way in which in Europe we've patted ourselves on the back wildly about this regulation. Everything is on that. Tier 2 academics are writing paper after paper about fairness and contestability. Youpidoo. Let's have a little bit more fairness. Let's have a little bit of it. Great. What's it going to do? Well, some sellers may be better off. Some app developers may be better off. The issue is rent extraction. Is not so much that. And the issue is dispersion of this power, which is gigantic. And it positions companies to be in place to effectively blackmail the state.
So I got it. So regulation can't be the only answer. I think that's the takeaway. But there's something more that I think you want to add as well. The title of your piece in Project Syndicate is Europe's tech regulation is not an economic policy. And you say that antitrust should be used to champion broader social and economic goals. I'm curious as to how to do that. But you also use this language in here. You say that Europe must, quote, encourage innovation by creating incentives for domestic investment and funding startups that are not the incumbents' vassals, end quote. So why don't you tell us a bit about what, if regulation isn't sufficient to do the trick to kind of reignite innovation in Europe, what else should governments be doing?
So I had a big fight with Project Syndicate about some of the language they used, including in the title. My title was, because they don't get nuances sometimes, my title was, it's not a full economic policy agenda. They didn't want, it was too long, so effectively they said not an economic policy, which isn't very clear. The specific issues we face in Europe are issues which are in some sense common to the United States. We have problems of inequality, of standards. The difference is that in the US, your economy is tracking, whether commentators recognize it or not, the economy is doing quite well, with pockets and all sorts of issues. In Europe, we are much more in a hole. We are in desperate need of a jolt and a shot in the arm and getting the economies moving. We have put all the eggs in this seemingly in this digital regulation basket. Now tell me how that's going to put points on GDP, how that's going to increase the GDP of Europeans. You go to an average European and he says, what are you doing for my wages? What are you doing for my job? What are you doing for the food prices? And you say, we're taming big tech, big deal. The voter doesn't care. So my point is, unless we are, yeah, that's all great, because I care about the influence they have on the democratic discourse and the size and the influence they have on governments. That's all kind of taken. But it isn't an economic policy in a year in which we're going to an election. So what we are watching, very interesting and timely, was the article that appeared on Washington Monthly on Monday, I think, by Rona Farhar. Rona is always incredible at essentially being a chronicler for change. And the way in which he has these great sweeping narratives there, which describes ways in which the current administration is reordering things, is very much something that I see. I titled my conference Antitrust Regulation and the Next World Order, because I do feel that we are at the point in which we are essentially in a paradigm shift, not just for antitrust and regulation, but for trade, for industrial policy. You would have been defenestrated in Washington if you'd spoken about industrial policy 5 years ago. This is no longer the case. In Europe, there was a time when you felt, well, very clearly, industrial policy and antitrust were enemies, because the job of the antitrust people was to defend against the barbaric national champions that were being pursued by the French and the German. Now there is a sense that, wait a minute, how are we going to grow? How are we going to grow? How are we going to put points on GDP? And in that, of course, it's not that antitrust will power the engine. But we know, and certainly you two do, that we've been presiding over years of lax antitrust, of merger control that was too lax, that has concentrated markets even further. And so in a world in which we are, in geopolitical terms, really watching a complete change of the dance. We can no longer party like it's 2007. And this is what I keep saying. People in antitrust, and we get to that at the end, who think that still we're here pursuing some notion of welfare or efficiency, are profoundly deluded. The change is happening. It's happening, interestingly, in the United States, as ever, in fact, because in Europe, we were at the receiving end of the previous paradigm shift, which was when President Reagan and Chicago and the Federal Society essentially ultimately sent emissaries to Europe during Bush presidency to tell the European Commission, read the memo. We are now doing consumer welfare. You better get on board. We are now 25 years later in a new paradigm. And I think people need to smell the coffee. Much as it's happening over there, we can also to sit here in Europe and say, oh, okay, we continue to do WTO deals like we've ever done. We'll continue to just consider in Brussels at the commission, at DG Comp, that industrial policy is the enemy. Christ, if we don't do industrial policy, what are we going to do for Europe if we don't coordinate?
You mentioned consumer welfare, which is, of course, a hot topic for me. Why is it not as what's the word, entrenched in Europe as it is here? It seems like it's almost a dogma in the United States, where it's not in Europe.
No, it's not. And in some sense, we're watching this battle for what I call the soul of antitrust, and your article was really extremely good at capturing this sort of the factions with interest, because we don't have that same debate over here. We can see, my perspective is that consumer welfare has become totemized as effectively the representation of the resistance. Okay, there is effectively a traditional school which identifies, yes, they call themselves pseudo-progressive, yes, they're post-Chicago, but it is still conventional, and that school claims to the notion of consumer welfare as a symbol of everything that we've done before being the right thing to do. In Europe, we've never fully embraced this consumer welfare as the lodestar. The tradition is somewhat different. We came from an ordo-liberal tradition. We've actually, though, embraced the whole notion of efficiencies, the whole notion that this is the purpose. But consumer welfare is not such a totem for Europeans as it is over there. Over there, it has become the sort of the focus of the dispute. Either you are essentially a traditional, effectively lawyer and economist of the IO school, or you are effectively a Brandesian, a progressive, or a populist, some would say, and you throw it away. We are less polarized over here, okay? But there is no question that the same sort of, I wouldn't say fight, but the same sort of problem is also live here. We have a resistance. Because of course we've been telling, I mean, we, the economists, we've been telling lawyers for 10 years, we need to do a more economic approach. What in Europe we call the more economic approach. Between 2000 and 2010, there was a huge push on the part of economists of the IO school, including myself, to just basically pursue and convince lawyers in court that we had to basically adopt these Chicago principles because efficiency was king. And
so
then
let me ask you about that, Cristina, because I've also written a lot about efficiencies in there, or the lack thereof, which you point out that in your piece that the Europeans are that is not as prevalent of in terms of importance as it is in the United States. So I'm kind of wondering, are the neo-Brandeisians really Europeans? I say that jokingly, but because they have those same kind of goals that you mentioned in your piece in terms of economic liberty and things of that sort that actually in the statute's legislative history, but gets ignored in the United States.
Well, that's a very good question, and I think that's why the ordo-liberal cast, the notion of economic liberty at the center of it, is something which still echoes very, very loudly in European minds. So we never quite fully embraced the consumer welfare sort of vision. And so when we hear here the neo-Brandeisian talking about what they talk about, it's more familiar. It isn't so alien. We don't have that dichotomy because we've never been embracing that fully. There's been a push to go there. And there is an entire body of advocates and economic consultants who are clinging to that sort of post-Chicago approach, and they're pushing it hard. But this is also why, the anti-monopoly narrative in Europe doesn't quite resonate. I keep saying to Darren and other friends, we need to find a different terminology. Because when you Americans talk about the original purpose, the original animating purpose of antitrust, I choke up when I hear Lina or Jonathan Cantus saying the original animating purpose is freedom from all masters. We will not serve a king, and we will not serve the kings of commerce. Now, to a European, that makes my hair stand on end. It's so powerful, it's so incredibly moving as a narrative. We kind of don't have that. Because our reality is more fragmented. When you talk to a French person and say anti-monopoly, they say, who you're talking about, the French rail? I mean, who is the monopolist over here? Is the French rail monopoly? It doesn't kind of evoke quite anything as powerful as it does in American history. And so, we have a different tone and a different set of issues. Of course, markets have concentrated over here. And innovation is, going back to Hal's question, what do I mean by that? I think when you look at any chart that shows kind of innovation sort of intensity in the US and in Europe is a rounding error, okay? And that is for a variety of reasons. Again, they're a fragmented continent. What are you going to do? An app in Dutch? What's the market? What's the addressable market of a Dutch app? None, or very small. So essentially, there is a language issue, there is a funding issue, there is no VC here who funds across Europe. So there are many, many structural issues. But like, you know, I see also in the US, we have Darren Acemoglu, who's been preaching for years that innovation, which is in the wake of incumbent giants, is preordained. It's not true innovation. Everything needs to look like an app because everyone in Silicon Valley is thinking of something they can sell to a digital giant. That's not the sort of the path of innovation that we want. In Europe, we are further behind. We really don't even have funding to it. The amount of technological innovation that happens is minute. Will digital regulation unleash the beast? Well, I hope so. But I think even in that dimension, it will be very limited because there will be incredible resistance on the part of the beast that will be unleashed. Okay, so the digital companies, the gatekeepers, will resist this opening up in the courts for decades. So I think something will happen, but we have a really serious issue here, which I think is not being talked about. You know, if you look at what the debate is in Brussels, there is conference after conference. You know, it's so boring about the DMA. Hey, pat on the back. What? What's that going to do? What's that going to do for the people in Italy or the people in Romania or the people in Spain where the GDP is flat or growing low?
Let me ask you this, Cristina, because we are running a little short on time. I want to hit the last topic on our discussion. I think we intended it to come third, but it's fine. It's this notion of ecosystem theories of harm. I know that you're pushing this idea, but for a lot of our listeners, they're going to be kind of scratching their heads. You know, what does it mean? How is it different from a traditional or conventional theory of harm, say, that you bring against the platform? So can you just talk at a very high level, and then maybe we could drill down and talk about how ecosystem theory of harm could have been applied to, say, another merger case, but wasn't? You know, how would you have structured it?
So yeah, I feel very strongly about this. I mean, quoting Jonathan Cantor when he talks about the merger guidelines, he keeps saying at every talk, we need to see how competition presents itself, right? And so this world in which we have horizontal and vertical no longer captures what we actually see. Something which in fact, the business strategy people have known for decades and have written about for decades is that competitive advantage is essentially driven by capabilities. It's not your market share in narrow market A that gives you a competitive advantage particularly. It's the network of assets and capabilities that you're able to put together, better if these are scarce or places where there isn't very much alternative. So what strikes me is that certainly we've seen it a long way coming. In Europe, I was involved in multiple cases in which the regulator was rightly beginning to sense that they needed to look more broadly than the standard structure. What is the standard structure? Let me just say this at the beginning because it is super important that we understand the difference. Yes, we had conglomerate deals before. In Europe, we had a number of cases that involve what we call conglomerate deals, not horizontal, not vertical, diagonal, if you like. The issue in those cases has always been, what is the leveraging mechanism that you are actually alleging, dear regulator? So the regulator knew that he had to have a structure in which there is market A, where there is market power, there is market B, where company could leverage that market power through some form of conduct, through time, through bundling, through some discounts, through some exclusivity. So there needed to be a mechanism. And we, the economists, were always, but what's your mechanism over there? And does it lead to foreclosure? Because unless it does, there is no problem. What has happened now is there is a sense that digital players, why is it more prevalent, more urgent now? Because A, the capabilities that are important have changed in the last 10 years, 20 years. We have algorithms, we have machine learning, we have data which are feeding into multiple markets. And the markets have evolved too. So this notion of the interconnection between these markets is clearly expanding significantly. And this interconnection can be both beneficial and problematic. right? So I did an event last night at University College London in which we had business people and regulators and judges. And, you know, the CMA was a pain to say, look, we don't regard every ecosystem as problematic. That's a description. But on the other hand, while you can have beneficial effects, beneficial products being created by an ecosystem, you can also have entrenchment. You can also have essentially using a deal in a new space as a building block for essentially occupying that space going forward.
Good. Let me ask you just one last question, I think, before we run out of time. Let's drill down to a specific case. I've got one in mind because it was the one that I was involved in, you know, the FTC's attempt to stop Facebook's acquisition of Within, which was, of course, pursued under a theory of potential harm to competition, right? Harm to potential competition. Could this have been reshaped as some kind of ecosystem theory of harm? And if so, how would you have done it? And if you don't like that example, pick a different one.
Because as you know, I was involved in that case too, and my own, without being giving too much away, my own view is that it should have been positioned differently, not as loss of potential competition in a tiny market. I couldn't see it certainly arguing, but as a situation in which you had a bad ecosystem owner, Facebook recognized so, making an acquisition in a new space, and that being potentially a building block for extending its monopolization, its dominance into that new space that could have been potentially important. So I personally would have wanted to frame the case. If it were down to me, I would have framed the case in that way, which I thought was much more promising and real. That, on the other hand, I realized that there are challenges in this. I mean, the judge last night at UCL, we had Sir Marcus Smith, who is the president of the Competition Appeal Tribunal, and he was concerned about crystal ball gazing and agencies going off on a frolic and essentially just designing futures that are not always plausible, and how does one distinguish those futures from reality. Now, that is inevitable when you're looking at things that are more adventurous. But, you know, Meta Within, to me, was a case where an alternative framing could have been possible. But let me give you actual examples. So one is Microsoft Activision. In Europe, we had two cases where we had two prohibition de facto. One was reversed by the CMA, the Microsoft Activision, but we had two prohibition on this basis. One was indeed Microsoft Activision, where, having put to bed the silly vertical foreclosure theory that Sony was pushing, there was a big concern about cloud gaming and whether the collection of assets that Microsoft had, cloud, operating system, hardware, software, data, and games, was going to lead Microsoft to a position of unattainable, unmatchable advantage in a new space like cloud gaming. And that was very much the theory there, which then was pushed back against and didn't really seem very plausible, but in any event was dealt with remedies. The second case, and I'll conclude, you may not have sort of had much to do with this, but the European Commission just blocked Booking's acquisition of Traveli, which is Booking, of course, as you know, is a giant in hotel bookings. Traveli is a travel agency, and the theory is pure conglomerate. There is no suggestion of any time bundling mechanism leveraging. The theory is by basically acquiring a service that is very close to what people want when they book a hotel, you are deepening the moat around booking. Now, this is very novel, because essentially you're using this theory to support the notion that the dominant company can entrench its dominant. They're not extending it to another market. So these theories can take different shapes, but they're a thing.
Got it. Well, we'll let that be the last word. Although I do want to say we were kind of potentially harsh on Europe. And I was, every time I go there, and I travel to Europe a lot for vacation, I'm just blown away by how beautiful the cities are over there. And I'd be so proud of what your cities look like compared to our cities. Some of our cities are a mess. You know, like you can step over bodies in some cities in the United States. And you just don't see that. I just think it's so gorgeous. I want to make sure that everyone comes away with the idea that Europe is doing pretty
Europe is
well,
gorgeous.
at least on the surface. I mean, for this dumb American traveler.
No. Look, what we've been talking about is different. Europe is totally gorgeous.
Okay,
That's no question.
All right. Well, Darren, do you want to come in and say goodbye too? But it was so nice having you on the show, Cristina, and I learned a lot. I hope our watchers
thank you so much
too. Darren, you guys
enjoyed the discussion.
All right.
That's great. Thank you both very much. Thanks for having me.
Have a good day. Bye-bye.